Part 3. ADR Entities and their work. In this module we look at ADR entities and their work. We look at ADR entities in a both consumer and a commercial context. We also look at the procedure for the enforcement of domestic arbitration awards in England and Wales. ADR in a consumer context. ADR entities in the UK are an initiative of the EU. EU initiatives for the promotion of a single marketplace and e-commerce has been the driver for ADR. The specific directive which is concerned with ADR is Directive 2013/11/EU of the European Parliament and of the Council, dated the 21st of May 2013. This is what the EU said when formulating this directive. Given the increasing importance of online commerce and in particular cross-border trade as a pillar of union economic activity, a properly functioning ADR infrastructure for consumer disputes and a properly integrated online dispute resolution framework for consumer disputes arising from online transactions are necessary in order to achieve the Single Market Act's aim of boosting citizens' confidence in the internal market. The EU directive further went on and said, the development within the Union of a properly functioning ADR is necessary to strengthen consumers' confidence in the internal market, including in the area of online commerce, and to fulfill the potential for and opportunities of cross-border and online trade. Such development should build on existing ADR procedures in the Member States and respect their legal traditions. It can be seen the EU directive has been enacted into UK legislation by regulation. The regulation is the Alternative Dispute Resolution for Consumer Disputes (open brackets) Competent Authorities Information (close brackets) Regulations 2015 and the Alternative Dispute Resolution for Consumer Disputes (open brackets) Amendment (close brackets) Regulations 2015. These regulations provide for the appointment of a regulator responsible for vetting and monitoring ADR entities which provide ADR in compliance with specified standards set out in the EU directives. The EU directive implements into legislation by national governments the back end of a front-facing platform provided by the EU. This is through a common platform available to consumers from the EU website. The consumer is provided with a central point from which to start a claim against a trader within the EU. This is a pan-Europe-wide platform enabling a consumer in one national state to bring a claim against a trader situated in another EU state. This can be done using either the European Small Claims Procedure or by utilising the out-of-court resolution bodies or ADR entities with which we are now concerned. Post-Brexit, the UK has been removed from the EU platform. This means that UK consumers are no longer able to bring a claim through the platform. Similarly, UK-based ADR entities are not able to accept a dispute from another part of the EU. The latest position is that we understand that the Chartered Trading Standards Institute is working with the government on a domestic platform. At this time, there is no alternative platform available to consumers. Common features of ADR entities across the UK, including the EU, are as follows. The ADR procedures should be free of charge to the consumer. The ADR procedures should be fair so that the parties to a dispute are fully informed about their rights and the consequences of the choices they make in the context of ADR procedures. The ADR entities should inform consumers of their rights before they agree to follow the proposed solution. Both parties should also be able to submit their information and evidence without being physically present. An agreement between a consumer and a trader to submit complaints to an ADR entity should not be binding on a consumer if it was concluded before the dispute has materialised, and if it has the effect of depriving the consumer of his right to bring an action before the courts for the settlement of the dispute. ADR procedures which aim at resolving the dispute by imposing a solution. The solution imposed should be binding on the parties only if they are informed of its binding nature in advance and specifically accept this. Specific acceptance by the trader should not be required if national rules provide that such a solution is binding upon traders. ADR entities in consumer sectors include Ofgem for energy, Ofwat for water, Ofcom for communications, even the Financial Conduct Authority. In other areas, the Secretary of State will be the generic competent authority, but has appointed the Chartered Traders Standards Institute to carry out these functions on his behalf. Examples of such ADR entities are the Rail Ombudsman, Retail Ombudsman, Legal Ombudsman, Housing Ombudsman, etc., etc. In a commercial context, there are no legal requirements who can provide ADR. This is entirely down to the parties themselves. On a basic level, there's a whole plethora of firms and barrister chambers providing some form of ADR. By way of example, we have chosen the propertymediators.co.uk. Examples of ADR at work. ADR does not follow the traditional pattern of legal proceedings. ADR is flexible and allows for its own procedures. The London Court of International Arbitration and the Singapore International Arbitration, the SIAC, have rules of procedure. These are quite extensive and apply in similar fashion to civil procedure rules, which have been enacted in more or less the same form in different countries simultaneously. Around 1999, we have the civil procedure rules in the UK. We also have civil procedure rules in Australia, Hong Kong. One big difference is that there are no formal requirements to be admitted to practice law before an ADR entity. This is useful where lawyers may appear before ADR entities away from their home jurisdiction. Since the COVID-19 pandemic, there has been a trend towards online hearings. This is a practical response to social distancing requirements and is more of a general response across the legal sector in any case. The advantages of ADR, however, is that it does not result in a hearing. Generally, consideration of the submissions and evidence is on paper. This is suited towards a less formal procedure and particularly useful in low value disputes. Generally, the procedures are designed for end users without the need for lawyers. For viewers who wish to see an example of the traditional form of mediation, there's a good video on YouTube posted from the Federal Court of Australia. The link is below. Turning now to the enforcement of enforcement or review of domestic awards. The enforcement process of the courts can be engaged once an award is either agreed or adjudicated upon within the ADR. The enforcement process includes using the High Court enforcement officers, third-party debt orders, charging orders, in other words, all the usual enforcement methods available to a party who has an award from the court. Reference to the court can still be made following an award on a point of law. In the case of ADR entities, the rules of procedure may provide that awards they make may not be binding on the consumer unless they choose to accept the award. The rules for registering an award can be set out in a step-by-step procedure as follows. Number 1, fill out the claim form for arbitration claims. Specifically, that's form N8. Number 2, attach evidence in the form of a witness statement, basically setting out the nature of the claim, the award made. Number 3, claim form has to be signed and verified by a statement of truth. Number 4, court fee required. At the moment, the fee is £66, usually paid by cheque, payable to HMS-CTS. Number 5, send 3 copies of all the documents to the High Court. The court will then issue the claim form and provide a claim number. It will seal the documents and return these to the consumer for service on the respondent or defendant, namely the other party to the ADR. The consumer will send 1 copy of the documents returned by the court to the defendant or respondent together with a response pack which has been provided by the court. Also included within the response pack will be form N15, which is acknowledgement of service. And after serving the documents, the consumer will file with the court a certificate of service within 7 days. If the defendants do not file an acknowledgement of service within 14 days, which is allowed, or indicate that they intend to contest the claim, then the consumer can proceed to ask for a final award. There will be an additional court fee payable for a writ of execution after the award has been registered. In any event, the High Court enforcement officers who you will use to enforce the award can help you with obtaining the writ of execution. In summary, the operation of ADR entities is becoming increasingly important. This is because of the combination of the expense and delay and complexity of the traditional form of legal proceedings. ADR is becoming attractive both for consumers and in a commercial context.